Mr. Malik.
Lords, I appear for the entry clearance officer this morning, who is the appellant in these proceedings. My learned friends, Mr. Kariko KC and Ms. Dunbo, appear for the respondents, BB and others.
Yes.
My Lords, this case concerns a family from Afghanistan. A member of that family, referred to as the sponsor, arrived in the UK in 2016 in the back of a lorry and claimed asylum. The Secretary of State refused his asylum claim, but the First-tier Tribunal allowed his asylum appeal. He was therefore granted refugee status and indefinite leave to remain. The sponsor's parents, his 3 sisters, and 2 minor children of one of those sisters sought to join the sponsor in the UK. They made their applications from Turkey, where they resided without lawful immigration status. The entry clearance officer refused their applications. They appealed against those refusals on the ground that the refusals were incompatible with Article 8. Judge Bennett at the First-tier Tribunal held that Article 8 was not engaged and there was no protected family life between the sponsor and the respondents, and Judge Bennett dismissed the appeal on that basis. Judge Bruce at the Upper Tribunal, however, set aside Judge Bennett's decision as being wrong in law. Judge Bruce took the view that the only rational conclusion open to the judge was that family life did exist. Judge Bruce therefore set aside Judge Bennett's decision and substituted a fresh decision allowing the appeal on Article 8 grounds. And this is the Secretary of State's appeal against that decision. As the court knows, the sponsor's father, who was one of the 7 original appellants, sadly passed away while these appeal proceedings were pending, and therefore this appeal relates only in relation to the decisions concerning the remaining respondents. My Lords, there are 3 grounds of appeal. The first ground is that it was not open to the Upper Tribunal to interfere with the First-tier Tribunal's conclusion that Article 8 was not engaged, and it erred in setting aside that decision. The second ground is that the Upper Tribunal erred in holding that Article 8 was engaged and that this was the only rational conclusion to be drawn from the facts. And the third and final ground is that the Upper Tribunal's assessment of proportionality under Article 8 was legally flawed. So subject to any observations, what I propose to do this morning is to address you first on law as it applies to all 3 grounds. I will then take you to the decisions made below and make submissions on the 3 grounds. So law, in my submission, the law is authoritatively set out in this court's judgment in IAA and others. That is the only authority. I'm sure my Lords would be glad to know that I propose to take you to in my opening submissions. The authority, Lords, is behind tab 12 of the authorities bundle. My Lords, if you look at paragraph 1 of the judgment, you'll see the basic background facts. You'll see that there was, in that case, a family.
Sorry, where are you reading from?
Paragraph 2 of the judgment.
Yes.
Lord. So there's a family of 6 individuals, father, mother, and children. And they sought to join the sponsor in the UK, who is the younger brother of the father. the appeal is allowed by the Upper Tribunal on Article 8 grounds. The Upper Tribunal held that Article 8 was engaged and that refusal of entry clearance was disproportionate. Lords, if you look at paragraph 9 of the judgment, you'll see that the court allowed the Secretary of State's appeal and then provided a summary of its conclusions. If you look at the first point that the court made, this is paragraph 10, you'll see that the point is that the consistent jurisprudence of the Strasbourg Code is that family life is normally limited to the core family, and there will be no family life between parents and adult children or siblings unless they can demonstrate additional elements of dependence involving more than normal emotional ties. This is the test. The court then clarifies at the end of that paragraph that the alternative test, which is real effective or committed support test, is lower than additional elements of dependency test. And that lower test is not the correct test. Paragraph 11, the second point, that Article 8 is not engaged directly in relation to individuals who are not in the United Kingdom. It is engaged through the sponsor who is in the UK. That is the territorial scheme of the Convention, Article 1 of the ECHR. And when it comes to the assessment of proportionality, the court is looking primarily at the Article 8 rights of the person who is within the jurisdiction, namely the sponsor, as opposed to the rights of individuals who are not in the UK. Paragraph 12, the Upper Tribunal in that case made several errors in relation to the question of proportionality. The test when it comes to the assessment of proportionality, the court said, is whether there were very compelling or exceptional circumstances. The Upper Tribunal in that case, this is paragraph 12, was wrong to pay little regard to the immigration policies of the Secretary of State and the UK government as reflected in the immigration rules. And the Upper Tribunal overstated the importance of short-lived family life between the sponsor, had it existed at all, and the welfare of the children and other family members. So these are the three conclusions that the court reached.
Has there been an appeal to the Supreme Court for this decision?
No. No, I have checked the position. There is
I know Mr. Speaker was in it. Okay.
Shall I address you on it when I'm on my feet? There's a good reason why there could be no appeal, because as you may have seen, the respondents themselves had no interest in the outcome of that case. They had no personal interest in the outcome of that case.
Lords, if you then go to paragraph 38 of the judgment, Lords will see a heading, the European Court of Human Rights and domestic authorities relevant to the existence of Article 8.1 family life between adult siblings. Under that heading, the court reconciles all earlier authorities on the subject. And if you go to paragraph 14.9, you will see that the court discusses the judgment in Mari. This is the judgment that is referred to at paragraph 10 of the judgment, which the court said sets out the test correctly. There is a quote from that judgment at paragraph 50. And may I ask you respectfully to look at the examples that are given. They are merely examples, but the court said something about those examples later in the judgment. This is paragraph 38 of the court.
38 of Kumari.
38 of Kumari, indeed.
Yes.
In cases where adults had a physical or mental disability or illness of sufficient seriousness and were in need of constant care and support from other family members, the court has accepted that such dependency may exist. So physical and mental disability or illness of sufficient seriousness that requires constant care and support from other family members. And then paragraph 39, conversely, the court has refused to accept that the state of health or their relatives were serious enough or sufficiently serious to warrant a finding of dependency in cases such as diabetes, heart condition, and a number of other conditions. Those conditions, this is the end of paragraph 39, were very serious indeed, but did not incapacitate the applicant to the extent that he was compelled to rely on the family's care and support in his daily life. Compelled to rely on the family care and support in daily life. If you go then to paragraph 60 of the judgment, so this is where the court comes to a conclusion following discussion of all legal principles. And the conclusion is that there will be Article 8(1) family life if there are additional elements of dependence involving more than normal emotional ties. So this is the conclusion of the discussion of statutory case law. Immediately under that paragraph, you'll see heading domestic cases on family life between adult siblings. And under that heading, the court discusses domestic authorities, including, of course, the well-known judgment in Kugatis. Now, if you then go to paragraph 82, where you will find a conclusion reached by the court as to the discussion of domestic case law. And the conclusion reached by the court is that the domestic case law also sets the test of additional elements of dependency. And at no stage the domestic cases stated that the test was real, committed, or effective support. Next, if you go to paragraph 95, you will see a heading Abbas. This is where the court considers the territorial scheme of the European Convention on Human Rights. And you will see from paragraph 97 what is said by the Strasbourg Court in Khan that was adopted in Abbas, which was adopted by this court. The positive obligation rests in large part on the fact that one family member is already in the contracting state, and that family member is prevented from enjoying his family life with other relatives. The transportation of that limited Article 8 obligation to Article 3 would in effect create an unlimited obligation on contracting states to allow entry to an individual who might be at real risk of ill treatment contrary to Article 3, regardless of where in the world that individual might find himself. So the difficulties that are faced by individuals abroad could be understandable, but they are not relevant for the purposes of an assessment under Article 8. The focus must be on the rights of the sponsor in the country. The conclusion reached by the court as to that discussion is at paragraph 100. A person who is outside the jurisdiction will not have their own Article 8 rights engaged. Article 8 is engaged simply by reference to the person who is in the UK.
I'm afraid I don't really understand the phrase "the jurisdiction of the ECHR" in that sentence. Can you help?
Sentence at paragraph 100.
Yeah, what you just read out. To enter an ECHR state from outside the jurisdiction of the ECHR. I don't understand what they're talking about there, I'm afraid.
Are they not talking about Article 1?
Yeah, I can understand if they said the jurisdiction of the UK, but they use the phrase the jurisdiction of the ECHR. Do they just mean the jurisdiction of the UK?
Yes.
Oh, okay.
Yes. Yes. That's got to be the case. Yeah. Yes. Immediately under that paragraph, you'll see a heading: the authorities relevant to the weighing of the proportionality balance, and the discussion then shifts to the exercise under Article 8.2. The court considers various authorities under that heading, and if you go to paragraph 116, this is where the court is bringing the discussion earlier in the judgment to a closure. And the heading above paragraph 116 is that the correct test to apply to determine if there is family life between adult siblings under Article 8.1. The court says 116 that the correct test is in Kumari at paragraph 35. And why is it that the court endorsed that test is explained at paragraph 117 onwards. The domestic courts have demonstrated willingness to follow the consistent jurisprudence of the Strasbourg Court.
You've passed over Bioku Betts in this helpful journey through the decision. That's a decision of the House of Lords, wasn't it?
Yes. So, yes. So what it says is uncontroversial, which is that when it comes to the assessment of proportionality under Article 8, one has to look at the family unit as a whole. The court says that there is no tension in that concept and in the notion that the focus must always be on the rights of the sponsor who is in the UK.
Does the decision in Bioku Betts align with the decision in Kumari?
There is no inconsistency. The decisions deal with two entirely distinct matters.
Yeah.
So Kumari concerns Article 8.1,
Okay.
engagement of Article 8. Bioku Betts concerns the assessment of proportionality
Okay.
under Article 8.2.
Thank you.
Paragraph 119. All cases make it clear that exercise of deciding whether there are additional elements of dependency is fact sensitive. 120, financial dependency and dependency created by mental or physical disability both play a part in the evaluation, but it is not necessary to demonstrate that one sibling is completely reliant on another. A point that is clarified, which is relevant in this appeal, is at 122, the real, committed, or effective support test. On a proper analysis is different from the additional elements of dependencies test. The two tests are different. And if you go to the next page, and if you look at paragraph 123, second sentence, real, committed, and effective support is not the test itself. I showed you a few minutes ago examples given in Kumari as to the sort of cases where Article 8 would be engaged. If you look at paragraph 125, you will see that the court said that it was undesirable to lay hard and fast rules. What is required is dependence, and you'll see a reference to Kumari again, and the sort of examples that may assist. So why is it that the Upper Tribunal in that case made an error of law that is dealt with under the heading, did the FTT and the UT apply the correct test? And if you look at paragraph 128, you'll see that the Upper Tribunal in that case referred to real, committed, or effective support test mentioned in Kugatis, and had applied that test to allow the appeal. End of that paragraph, the court says that that test is different from the correct test, and that was an error of law. The second error that the Upper Tribunal made in that case is dealt with at paragraph 133. The focus of the evaluation of whether family life exists should be on the relationship between adult siblings. The fact that they have not lived together for many years is relevant. And if you read that paragraph with paragraph 136, you'll see that the court concluded that none of those matters reach the level of dependence that is required to establish family life between adult siblings. Second sentence of paragraph 136, the court again endorses the point that is made earlier, that family life for the purpose of Article 8.1 is primarily that of co-family, normally cohabiting together. The brother and the sponsor have not cohabited for many years, and that meant that there was no family life.
Mr. Malik, can I ask you about that conclusion? It might be said that's a conclusion of fact, whether family life exists or not in a given case. And yet this court seems to have been perfectly content to decide that question for itself. So is that the correct way of looking at what's happened?
Yeah, so the findings of fact are of course made by the tribunals.
Yes.
But the question as to whether those findings justify a conclusion that there is protected family life,
yes,
is one that the appeal court can take,
right,
without any difficulty, and that is the approach that this court did. They said that, essentially proceeded on the findings of fact made by the tribunals, and said that, those findings do not justify the conclusion that is reached.
Yeah, forgive me for not making myself sufficiently clear. usually there are findings of primary fact. Then a court or tribunal often has to draw some conclusion, make some evaluative assessment of what they amount to. Do they properly come within the concept of family, for
Yes.
example? And it was that latter exercise that I was focusing
I
on.
see.
But what seems to have happened after the analysis by this court, which you have shown us, the ultimate result is that this court concludes for itself
Yes.
that there was not family life in this case.
Yes.
And presumably, am I right in thinking that if, and I stress, if we thought there was merit in your grounds of appeal, you would also invite this court in the present case to form its own view about whether on the primary facts as found by the FTT, does that or does that not amount to family life?
Absolutely. So if I fail in my ground one, so my ground one is that there was nothing wrong with the first-tier tribunal's conclusion,
Yes,
and the court should simply reinstate the first-tier tribunal's decision.
I see.
But if you reject my ground one and take the view that there was an error of law in the first-tier tribunal's decision, then I do ask you, this is my ground two, to find that there is no family life.
And I see here in paragraphs 130 and 131, the court discusses whether to remit or remake the decision.
Yeah. Yes, so if there is a dispute about primary facts, and of course it wouldn't be appropriate for this court to sit to resolve that dispute. But where findings of fact have already been made, there is no difficulty in the court substituting its own decision.
They say that in that case it's not a finely balanced decision. I don't know whether they'd have taken a different course if it had been a finely balanced decision.
Yes. So this is paragraph 136. Well, yes, it is. My Lord is absolutely right. A conclusion on fact in that sense, but there is at paragraph 136 a legal principle that is endorsed, which is that family life, for the purpose of Article 8, primarily exists in the co-family, normally cohabiting together.
Yes.
So what were the other errors made by the Upper Tribunal? Now, in that case, in my submission, just like this case, the Upper Tribunal placed too much focus on the circumstances of the applicants who were seeking entry clearance who were not within the jurisdiction of the UK. And if you look at paragraph 139, you'll see the court quoting a paragraph from the Upper Tribunal's decision. And you'll see that there was a conflict of authority at that point at the Upper Tribunal level. Well, this is the Biaku-Betts discussion. There were two inconsistent decisions of the Upper Tribunal, Al-Hassan and KF, both addressing Biaku-Betts. KF, in short, said that the circumstances concerning the applicants abroad are not relevant at all. Al-Hassan said that, no, that isn't quite right. You look at the family unit because that is what Biaku-Betts requires you to do. Paragraph 142 is the conclusion as to that point. Even if family life had existed between the sponsor and the family members, that would not have meant that Article 8 rights of the brother or family outside the UK were the main focus of the proportionality exercise under Article 8(2). Main focus of the proportionality exercise. That was the error that was made by the Upper Tribunal in that case. The court said that conclusion wasn't inconsistent with Biaku-Betts. If you then look at paragraph 148, you'll see a heading, the allegedly tenuous nature of the family life. And under that heading, paragraph 151, the court again, between letters D and E, make the point about the fact that the family had not cohabited for many years. There was a connection between family members again, but in the knowledge that the family had no right to enter the UK, and if their applications failed, the sponsor would be joining them in Gaza.
Well, that doesn't directly have an analogy in the present case, does it? Because there's no question of the sponsor going to live in Turkey.
No, indeed. So the reason why I show you this passage is the earlier point that is made by the court, which is firstly that they haven't lived together for many years,
Right.
and when they started the contact again, that was in full knowledge that the family had no right to enter the UK.
Yes.
So when the sponsor in our case re-established the contact with the family in Turkey, he knew, and the family knew, that the family had no right to enter the UK. Welfare of the children, that is dealt with under a heading above paragraph 153. As the court knows, Section 55 of the 2009 Act is not engaged in relation to a child who is not in the UK. But the welfare of a child is a relevant consideration. If you, bearing that in mind, if you go to paragraph 158, you'll see a reference to the judgment of the Supreme Court in Agyako. And what a tribunal is required to do is to attach considerable weight to the Secretary of State's immigration policy, not merely acknowledge its existence or bear it in mind, but to attach considerable weight to it at general level. That I shall submit is one of the errors that the Upper Tribunal made in this case. Considerable weight.
I'm sorry, Mr. Malik. How is this discussion of the welfare of children relevant to the present case, where the sponsor is an adult?
Because there are two children in the family.
Oh, right.
No. So the sixth and seventh appellants
Yes.
are minor children of one of
Right.
the adult sisters.
Okay. So you accept that their welfare has to be taken into account in this assessment?
Yes.
I see.
Yes. But not, my lord, pursuant to any Section 55 obligation, because Section 55 is not engaged, but pursuant to Article 8. And their welfare is relevant. Under that heading, the court discusses as to how welfare of a child is to be balanced against the public interest in having effective immigration control. So the starting point is that the decision maker must attach considerable weight to the Secretary of State's policy. So there are immigration rules that allow family members, including children, to join their family members in the UK. That is Appendix FM to the immigration rules. And the Secretary of State's policy is that she would allow individuals to join family members in the UK if they meet those requirements. If those requirements are not met, then that is to be given considerable weight in the assessment of proportionality. Paragraph 159. The Secretary of State's policy. It's not the Secretary of State's policy to admit all persons who share family life with a person lawfully settled in the UK. And this isn't a question of floodgates and numbers. Likely to that individuals would apply from war zones. It is the question, the court said, for the UK's laws and democratic process, and for what the government determines is necessary in that society to protect economic well-being of the UK. Really comes down to respecting the democratic process. The Secretary of State, as the court knows, is is responsible for immigration control. The immigration rules are made pursuant to a democratic process. They are laid before Parliament by the Secretary of State and approved by Parliament by an agreed resolution procedure. Paragraph 160. The family life can continue by online contacts. The court said in that case the personal circumstances had to be balanced against the Secretary of State's policies reflected in the rules, which did not allow them to do so on the ground that they risk, grounds of risk they faced in a war zone. That is the relevance of the absence of a resettlement policy concerning Gaza. Had there been one, the policies of the Secretary of State might have favored the family and allowed the balance to be struck differently. So the immigration rules reflect the Secretary of State's policy and ought to be used ordinarily as to how balance is struck. There is then a heading above paragraph 162, immigration control as part of public interest. And under that heading, if you look at paragraph 166, you will see that in that case, unlike this case, the Upper Tribunal said that it was placing considerable weight to the Secretary of State's policy. But despite saying that, the court said that the tribunal failed to do so. Last sentence, the UK gave wrong weight to the Secretary of State's policies as reflected in the immigration rules, which did not allow families from this war zone to join family members settled in the UK. So a tribunal saying that it attaches considerable weight is not enough. The court has said. Paragraph 167, the policy is the matter for the Secretary of State and the government. And again, it's not a question of flood zone or numbers. It is simply an endorsement of the respect for the democratic process. And last sentence of paragraph 167, that considerable weight should be given to the Secretary of State's immigration policies. Considerable weight. And if you attach considerable weight to the Secretary of State's policies, paragraph 168, only a case that is very exceptional or compelling would succeed. The UT could only, in effect, override those policies in very exceptional or compelling circumstances. The court said that there were no very compelling or exceptional circumstances on the findings of fact. The court conducted a proportionality balance itself under the heading above paragraph 169. On the basis of the findings made by the tribunal and took the view that there was no disproportionate interference with Article 8. The court allowed the appeal, set aside the decision, of the Upper Tribunal and remade the decision, holding that there was no family life, and if there was family life, there were no very exceptional or compelling circumstances. This is paragraph 178. There were no very exceptional or compelling circumstances justifying the grant of entry clearance. So this authority, in my submission, sets out the law that this court must apply. May I then show you the First-tier Tribunal's decision and then the Upper Tribunal's decision and make submissions on the three grounds. First-tier Tribunal's decision is in the core bundle, and it starts at page 97. The judge deals with a number of procedural matters, sets out the evidence that the judge heard in great detail, records the submissions that were made by the parties, and its discussion, the judge's conclusion, commences at paragraph 65 of the decision. See a heading, reasons for decision, and this is really the findings of fact. The judge acknowledges that the sponsor has a serious and long-term mental health problem. And in the last sentence of paragraph 66, the judge accepts, and no one disputes that, the condition is affected by the fact that the family members are residing in Turkey, and if they are able to join the sponsor, his mental health will improve. The real question, the judge said at paragraph 67, the first question is whether family life exists. The judge refers to Gugatis and paragraph 71 acknowledges that there has to be something more than normal emotional ties, love and affection. Now, if there is an error of law in the First-tier Tribunal's decision, it is at paragraph 72. But this is an error in favor of the respondents. The judge says that the question is whether the appellants can show that there are probably stronger ties with them and the sponsor than ordinary emotional ties existed between adult relatives in terms of love, affection, and concerns, because the test, they provide real, committed, or effective support. Now, this is the test, a formulation that was used by Lord Justice Sedley in Gugatis. The court has made it clear that this is the wrong test. It is lower than the actual test. The judge makes an error in favor of the respondents, applies the lower test. And the judge concludes that that lower test was not met. The judge makes findings of fact about 5 matters. The first matter is at paragraph 74, and it concerns separation of the sponsor from the family and the fact that they resided in different continents for many years. That is the first point judge makes, a point that IA says is of course relevant. The second finding is at paragraph 76, and it concerns claimed financial dependency the judge makes a finding of fact that there is no financial dependency. The finding is that there isn't any evidence of the sponsor sending money to the family in Turkey. But even if there is remittances, that would not make the respondents financially dependent on the sponsor. And conversely, the sponsor is not financially dependent on the respondents because the respondents do not send him any money. So no financial dependency. The third finding is at paragraph 78. It concerns the contact between the sponsor and the respondents. The contact was re-established in 2019, 3 years after the sponsor came to the UK. There are regular telephone calls, and that evidence is not challenged. No one disputes the fact, and the judge makes a finding that they are in regular contact with each other.
So what's the relevance of this? This seems to be a sort of negative factor. Is that right? Is it to be taken into account as diminishing the existence of family life? Is that right?
No, my reading of it, this fact, my lord, is that this was a factor that was in favor of the sponsor and the respondents. The judge was acknowledging the fact that they were in contact.
It was setting the parameters of their relationship.
Yes.
It was a feature. He was describing a feature of their relationship.
Yes.
In order to decide whether it was family life.
Indeed. A feature that is in favor of the sponsor and the appellant. So if, for example, there is no contact, then that is indicative of the fact that there's no family life.
But there can be many reasons why there's no contact. I mean, one thinks back to the 1930s, when Jewish refugees were escaping Nazi Germany. Suppose they hadn't had contact with their family for 3 years, while the refugee is in the UK, and they've not been able to maintain contact with their family for 3 years. What? I'm sensing that in some way that's a negative factor, that you haven't had contact. But doesn't one need to explore why there hasn't been contact for 3 years?
Yes. So, my lord, the judge, as I read paragraph 78, places no reliance on the fact that there hasn't been contact between 2016 to 2019.
Right.
The judge is focusing on the post-2019 contact.
And you wouldn't invite this court to place any negative weight. Okay, that's it.
So there was, of course, separation from 2016 to 2019.
Yes.
But that isn't a matter that goes in the Secretary of State's, the Anti-Clearance Office's favor. The judge hasn't taken that factor in that way. The judge acknowledges that since 2019, there is regular contact. The sponsor has visited the family in Turkey twice. That is the third finding. The fourth finding relates to emotional support. That is paragraph 79 onwards. The contact, the judge says, does not amount to emotional dependency or support. And it isn't anything more than a manifestation of ordinary emotional ties between adult relatives. The judge, in my estimation, makes a valid point, which the Upper Tribunal felt wasn't a valid point to make, which is that if there is a family member who is unwell, or if there are concerns about well-being of a family member, then it is quite normal for extended family members to stay in touch for a prolonged period, to speak to each other more regularly, and to stay in touch. The judge in the Upper Tribunal picked a sentence from paragraph 80 of this decision, Paragraph 80 is reference to a meeting that took place between the sponsor and the family in Turkey. And the evidence that the judge accepted is that that was a highly emotional event. No one disputes that. The judge says that, but the joy does not establish family life, because any close relatives who were reunited in similar circumstances would be overjoyed, irrespective of whether family life existed. The point that the judge is making isn't any wider than simply saying that if you haven't seen your parents for a very long time, if one of them is unwell, if you see them, that would be an emotional event. But that does not establish emotional dependency or sustained emotional support. That end of paragraph 81 is indicative of ordinary love and affection that close relatives have for each other. A child will have with parents. Paragraph 83, the judge accepts, and no one disputes that when the sponsor and the respondent speak to each other, they derive much pleasure from that contact. It raises their spirits. They feel low when they cannot sport. They worry about each other. In paragraph 84, the judge says that, well, this is manifestation of emotional ties between adult relatives, between an adult person and his parents. That does not mean, paragraph 84, second sentence, any real, effective or committed support over and above those normal emotional ties. So the finding is that there is no emotional dependency.
When we're evaluating this sort of thing in family life and thinking obviously about other areas where this has arisen professionally, Mr. Malik, as you'll appreciate.
Yes.
We don't look at snapshots, do we,
No.
of meetings,
No.
thinking particularly of sibling relationships, which we characterise the family jurisdiction as lifelong relationships. We wouldn't say evaluating a relationship between brother and sister. You just look at one meeting. You look at the whole picture, don't you?
Absolutely. Absolutely. My Lord is absolutely right. So in this case, the sponsor highlighted what had happened in one particular meeting and gave evidence that, well, see how emotional that meeting was. And that indicates, if I may just put it in that way, that indicates that there is emotional dependency because of the way they interacted in that meeting. A point that it isn't the entry clearance officer asking the judge to look at one meeting in isolation. The sponsor asks the judge to look at what happened at that meeting. And the judge records that. But that, my Lord, as you know, is one of the many points that the judge makes. My Lord is absolutely right, that it's ultimately an evaluative exercise rather than a snapshot. But the judge isn't taking a snapshot in my submission. The fifth and final finding that the judge makes concerns cultural consideration in relation to a family from Afghanistan. Men, the judge says, in that society are expected to look after the woman. And the father, who has passed away, sadly, was aging, and the sponsor and the other family members would like the sponsor to take over his role. And the sponsor was likely to do so. The respondent's end of that paragraph may accord him the nominal status of head of the family, but that does not mean that there is real, committed, or effective support. So looking at all this in the round, and this is the point that Lord Justice Baker made, it isn't a snapshot of one event. Paragraph 88, the judge says, well, looking at all the evidence in the round, everything that the judge says I have recorded, I do not accept that there is family life. And the judge applies the lower test and concludes that there is no family life. Now, in my respectful submission, there is no material error of law in the judge's decision. The judge applied the test that is more generous to the respondents. If that test is not met, it is inconceivable that the higher test stipulated in IA would be met.
Mr. Malik, if you're about to move on to something else, can I ask you about the evidence in the supplementary bundle?
Yes.
But don't take this out of order if you're coming back to it. But in the last part of the supplementary bundle, we have a number of reports, two by Mr. Perkins. There's, forgive me, I'm going to get the pronunciation wrong, but Dr. Galapathy.
Yes.
And Ms. Jones, the social worker.
Yes.
Was that material before the FTT?
Yes. Yes.
It was.
Yes.
And does the FTT judgment deal with it?
Yes. Yes, indeed.
Can you just show me?
Absolutely. Yes. Yes, indeed. So. So paragraph 66. So this is the first paragraph, my lord, that I showed you. My apologies for skipping over.
No,
the details.
not at all.
So I showed you the first sentence where the judge finds that the sponsor has serious and long-term mental health problems.
Yes.
And if you look at the remaining paragraph, the judge discusses the expert evidence. And the judge concludes that he has no hesitation in accepting the expert evidence that mental health is affected by the concerns about the respondents' welfare, and it would significantly improve if the respondents are able to join. So what is said in the medical evidence is not controversial. The judge has made a finding about it. So I do not dispute the fact that there is long-term mental health issue, and mental health would improve if the family is able to join.
But could it be said that the sponsor's mental health does bring him within the concept of dependency on the medical evidence, or do you say that's not sustainable?
That is simply unsustainable. So I've shown you the relevant paragraphs in I and others. There were sort of mental health issues in that case as well. Well, at the risk of generalization, I do make the point that it is not uncommon to see refugees from war zone to have mental health problems.
And PTSD in particular.
Exactly. And if you know that you are able to fled a war zone and now in a safe haven, but your family remains in very difficult situation, then it's bound to have an impact. And mental health is bound to significantly improve if the family is able to join the sponsor in the UK.
All I'm suggesting is that might be said to be more than the normal emotional ties that any family of adult siblings have. But I think you would say maybe so, but it's still not enough to meet the high threshold of what family life is.
Yes.
All right.
Additional dependence. So why is it that the Upper Tribunal set aside the First-tier Tribunal's decision? May I take you to page 73 of the bundle? This is the Upper Tribunal's error of law decision. and if you look at paragraph 68, page 78 now. So page 78, grounds of appeal, discussions and findings. And there are really two paragraphs that are relevant, paragraphs 70 and 71. Other paragraphs deal with an issue that is no longer live. So paragraph 70.
Can I just take you back, page 18?
Yes.
Just to see what's happened with the paragraph number, because it begins with paragraph 52. Is that right?
That is right, and I know why that has happened.
My lord, and that's resulted in our paragraph numbers being wrong. I think there were two different versions of the error of law judgment was promulgated first by itself and then secondly as an adjunct to the first.
I see.
So
we're not missing anything.
No.
Just
So what happens, my lords, is that when the Upper Tribunal remakes the decision, it attaches the error of law decision as an annex. And it's a common feature of Word that if you copy and paste from your error of law decision,
You lose the paragraph numbers.
at the end. So,
Right. So we go to paragraph 68.
yes, paragraph 68 of yes. So this is actually an annex to the remade decision. So 68 and 69 you can skip over, my lords. That deal with a point that is not relevant. So 70 and 71. That's really the issue. And paragraph 70 is, with respect, indefensible. See the last sentence. The tribunal's search for some ever more extreme emotional attachment meant that it failed to stand back and ask itself the simple question: is here evidence of real, effective, committed sport? That we know is not the test. And if you look at the earlier part of the decision, the judge picked a sentence, as I said, from paragraph 80 and said that the tribunal dismisses Mr. Perkins' evidence about intensity of reunion. But with respect, Judge Bennett was accepting the evidence rather than dismissing it. The judge said that any close relatives who were reunited in similar circumstances would be overjoyed. That was a clear error. In my submission, that wasn't an error. The judge was simply making a point that where family members have not met for many years, they meet, then that is bound to be an emotional event. But that does not establish emotional dependency. Paragraph 71, the judge says that the answer to the question must...
Sorry, forgive me, can I just go back to paragraph 70?
Yes.
For the purpose of ground one of your appeal, we're not considering at that juncture IA.
Yes.
Because you're taking the pre-IA
Yes,
understanding of the law, and your submission under ground one is simply that even applying Kugathas,
yes.
the FTT had not fallen into error,
Yes.
and the Upper Tribunal was wrong to say so. So is it your submission that in the last sentence of paragraph 70, when the FTT is accused of having failed to stand back and ask itself a simple question, is there here evidence of real effective committed support? Well, what do you say? Do you say that the FTT in fact had done exactly that?
Precisely. So the first-tier tribunal identified that as an issue, as a test, and made entirely sustainable findings. The only alleged error is in paragraph paragraph 70 of this decision, which refers to paragraph 80 of the first judge's decision.
Yeah, can I just be clear? IA hadn't yet been decided, and indeed hadn't yet been decided at the time of the later decision, as I understand it.
Right, yes.
But when we look now at whether the Upper Tribunal was justified in interfering with the First-tier Tribunal's decision, we have got to do so through the eyes of IA, haven't we? I mean, it doesn't perhaps matter on your case, but we can't say, oh, well, as the law as it was then understood, the first tier went wrong. We have to take into account the law as it has turned out to be subsequently, don't we?
So for purposes of ground one, I proceed on the basis that the test is real, effective, and committed sport.
Mm.
So that is the test that we know is lower than the actual test.
I mean, I quite follow you can say it really doesn't matter that the first tier applied the wrong test because it was a test that favoured the now respondents.
Mm.
But supposing that the position had been different, I can't see how you ignore what has turned out to be the law in deciding whether or not there was an error of law in the original decision.
Lord, if the first-tier tribunal had found that there was real, effective, and committed sport, and had allowed the appeal on that basis, then there would have been an appeal on the ground that the first-tier tribunal got the test wrong, as IA has clarified. And that perhaps is the distinction. That the way I respectfully invite the court to approach this is that the first judge applied a test that is more generous. Is there an error of law in the judge's conclusion as to that test? If there is, then of course we move to the other grounds. If there isn't, then the lower test is not met, and that is the end of the appeal for the respondents.
Is another way of looking at it that confining ourselves only to ground one for the moment, that there was an error of law by the FTT,
Yes.
but it was not material
Yes.
because it was more generous to the respondents
Yes.
than IA now tells us it should have been.
Yes.
But as my Lord says, we can't ignore, even in addressing ground one, can we, that the law, as correctly stated, is stated in IA. But you might, I don't know, I'm not trying to put words in your mouth, but you might say that the FTT did apply the wrong test in law, but it was not material to its decision because it was acting more generously in favour of the respondents, and even so found against them.
Yes. Yes, Lord, the answer might be in Section 14 of the Tribunal's Courts and Enforcement Act 2007. So the task of this court is to decide whether the Upper Tribunal made an error of law. If the court decides that the Upper Tribunal made an error of law, the court can and should set aside the Upper Tribunal's decision. The next question is whether the First-tier Tribunal made an error of law. The court will conclude that the First-tier Tribunal made an error of law. But the statute says expressly that the court is not obliged to set aside the decision. It may, but need not to, are the words that the statute uses. It would be perfectly legitimate for the court to say that there is an error of law, but we do not set aside that decision, we reinstate that decision.
I mean, as you say, plainly the first tier, as we now know, made an error of law because it applied the wrong test.
Yes.
But your point is it was a test that was adverse to the Home Secretary.
Yes. Yes. So this is one way of dealing with the appeal. Of course, if I'm right on ground one, another way of dealing with this is to set aside both decisions, to set aside the Upper Tribunal's decision and the First-tier Tribunal's decision, and then substitute a fresh decision dismissing the underlying appeal on the basis that, on the findings of fact, a more generous test is not met. And that, by default, means that the actual test is not met.
Well, that's what I was wondering, whether you do invite us to do that, and you do, certainly if we allow your appeal on ground two,
Yes,
as I understand
indeed.
it.
Absolutely.
But does the Secretary of State, you represent the Secretary of State, do you, on behalf of the Secretary of State, have a preference which you invite this court to take? Do you invite us in a linear fashion to go through ground one first? Or do you say it doesn't really matter, that you may take the view that, given where the law now is, that we need to get the law right, and it's ground two which is the critical ground? Or do you not have a preference?
No preference.
All
It doesn't really matter.
We could, looking at ground one, would it be permissible to say, in the light of IA, it was not open to the Upper Tribunal to interfere with the FTT's conclusion that Article 8 wasn't engaged nor set aside its decision. So we could, we would simply be reinstating the decision.
Yes,
That's how you've
Yes.
framed the appeal
Yes.
to start off with, isn't it?
Yes, so that my lord, is one of the two ways in which, yes, in which you the court can deal with the appeal.
But analytically, how then does ground one differ from ground two? If that's the course we take.
So ground. Yes, at one point, my lord, I accept, of course, that both grounds one and ground two to meet merge at one point. But ground one essentially is whether the Upper Tribunal was entitled to set aside the First-tier Tribunal's decision. It matters not, of course, which route the court takes. These are two or possibly three options available to the court if the court is persuaded that.
I notice your grounds of appeal was settled 2 days before the judgment was handed down in IA.
Yes, indeed.
Of course, you can't possibly know the result because of the embargo.
It was embargoed, indeed. So the judge, Judge Bruce, therefore, in my submission, was wrong to set aside the first judge's decision, either because the judge had applied the generous test, there's nothing wrong with the findings of fact, or in light of IA, the Upper Tribunal wasn't entitled to set aside the decision on the basis that it did. The difficulty in my submission that the Upper Tribunal faced at the remaking stage is what the Upper Tribunal said in the final sentence of paragraph 71. Essentially that, well, the only conclusion is that there is real, effective, committed emotional support and family life is engaged.
And just before you move on to that, I mean, that is an alternative basis for the Upper Tribunal overturning the First-tier Tribunal decision. I mean, if the First-tier Tribunal was not sustainable rationally, then obviously it had to go.
Yes. So this point, indeed, is the alternative basis. But the reason why I have to deal with it, because it goes into the remaking decision. So this is now ground two.
Yes.
The judge says that I'm finding that Article 8 is engaged because the only conclusion I can arrive at is that there is real, effective, and committed support. That is the wrong test. Remade decision, page 81 of the bundle. And the Upper Tribunal had already decided that family life is engaged based on the wrong test. And therefore, the remade decision is, with respect, unsustainable. There can be no doubt that the Upper Tribunal applied the wrong test. Look at paragraph 28 of the remade decision. The Upper Tribunal quotes from the earlier error of law decision. And of course, you have seen the final sentence of that paragraph.
Sorry, which paragraph?
Paragraph 28, which is at page 90, so, which is a quote from the error of law decision. The judge says, well, these are my reasons for concluding that there is family life that is unsustainable. The judge then says that, well, I have now become aware of two Strasbourg authorities, and what the judge said about the two authorities is indefensible, flatly inconsistent with IA and others. The reason for that, my lord, is that if you look at paragraph 30, so I'll skip over 30 to 32 and ask you to look at 33, where you have the conclusion of Upper Tribunal Judge Bruce. Line 6. there is no presumption of family life between adults, and one will only be established if there are more than normal emotional ties, yes, or alternatively, evidence of real, effective, and committed sport. Well, that is just wrong. The real, effective, and committed sport is not the alternative test that one can meet to succeed, and therefore the judge in my submission applies the wrong test.
I mean, can it be said, you say with the first-tier tribunal, it really doesn't matter that the first tier applied the wrong test. Might the same be said here? Because the upper tribunal goes on to say, well, even if I'm wrong about this, the higher test will be met.
Well, in my submission, no. The reason, Lord, is that if you look at that paragraph, you'll see that the judge first says what Kumari and the other specific authority has said. The conclusion the judge reached is that these are two alternatives. And the judge then says that I do not read the cases to import a requirement that there must be a dependency of a complete dependency. The judge says, if I'm wrong, it does not matter, since in this case, such a test would, in my view, be met. It isn't, in my submission, entirely clear what the judge says is the test that is met.
It's certainly higher than the real, effective, and committed support.
So the judge says the evidence is understanding the inability to overcome severe mental illness that impairs every aspect of his life. Only by being reunited with them, he will be able to recover and live a meaningful existence.
Mr. Bowder, can I put to you how I read the second half of that paragraph? And please correct me if I'm misunderstanding you. The second half of that paragraph, 33, it begins, I do not read either case. So in other words, Kumari or Alvarado in Strasbourg, I do not read either case to import a requirement that someone involved must have a condition which leaves them, absent their family's member care, entirely incapacitated. If we miss out the next few words, if I'm wrong about that, it does not, however, matter, since in this case such a test would, in my view, be met. So is the judge saying, if in fact the test is that the person will be left entirely incapacitated, such a test would, in my view, be met? The extraordinary degree to which S has come to focus. And he then outlines the medical evidence, which is why I asked you about it earlier. I mean, is that one way of reading that?
That is yes, one way of reading that paragraph. In my submission, that is not, with respect to the right way of reading that paragraph. But if that is the right way, then this conclusion is in my submission, unsustainable. There's no reasons as to why it is said that the sponsor is entirely incapacitated. And the judge, in my submission, couldn't be saying that, because the evidence does not justify it.
I mean, you've referred before to the reluctance of appellate courts to interfere with findings of fact. Here you have an upper tribunal judge who hears oral evidence, who hears the evidence, makes findings, and he finds only by being reunited will the sponsor be able to recover and live a meaningful existence.
My understanding, my Lord, is that the upper tribunal did not hear evidence. No. Did it? No.
Yes. So the Upper Tribunal heard evidence from both the sponsor and
Heard
Mr.
the sponsor. Yes, indeed. So they heard, yes, so if the Upper Tribunal is saying in this paragraph, if the Upper Tribunal is making a finding that the sponsor is entirely incapacitated, then that is, in my submission, unsustainable finding. It is not adequately reasoned, and it is not justified. My primary submission remains that the judge got the test wrong. So, my lords, if I fail on ground 1 and if I fail on ground 2, if you conclude that the Upper Tribunal was entitled to find that there is family life, then ground 3 is the alternative ground that concerns the assessment of proportionality.
Obviously, we have no views whatsoever on any of these grounds or arguments. But if we conclude that we do allow your appeal on either ground 1 or ground 2, on your submission, do we need to address ground 3?
No. That would be the end of the appeal.
Can I just go back to what the Upper Tribunal judge was doing at paragraph 33?
Yes.
Do you accept there that although he didn't have the decision in IA, we were wondering earlier, she, forgive us, whether she had, although she didn't have the decision in IA, she had the decision in Kamari, which was an integral part of this court's rationalisation of or establishment of the test. And wasn't she applying that test to the facts, to the evidence as she found it?
No, in my submission, she got the test wrong. The way she read Kumari is, in my submission, entirely inconsistent with the way in which the court read Kumari in I and others.
Yes. I mean, in paragraph 33, she says, nothing in Kamari is at odds with my reasoning. You say, IA has made it clear that it is at odds with her reasoning.
Absolutely. Lord, the answer to the question that Lord Mr. Singh asked is that, well, ground 3 only arises if I fail on the first 2 grounds.
Yeah.
And that ground concerns the assessment of proportionality. We assume that Article 8(1) is engaged and there is family life. In my submission, the approach to proportionality is fundamentally flawed. The first reason for that is at paragraph 36. The judge says that the policies, the immigration rules are matter for the Secretary of State. I bear in mind that maintenance of effective immigration control is in the public interest. That, in my submission, is just not enough. It's not enough to simply bear in mind that maintenance of effective immigration control is in the public interest. Very considerable weight should be given to the Secretary of State's policies. Secretary of State's policies are reflected in the immigration rules. Appendix FM, just for the purpose of your note, the relevant paragraph is at tab 3 of the authorities bundle, sets out the requirements that a family member must meet in order to qualify on Article 8 grounds to join another family member in the UK. Those requirements are not met. There is no scheme for those who are in the position of this respondent. Paragraph 36 is wrong in law, and the starting point is wrong. The judge then attaches weight to 2 factors, that the respondents are unable to speak English, and that they would be a burden on public purse in the UK. effect, my lord, is that the sponsor does not work. The sponsor is reliant on public funds. And if the respondents are allowed to join him, then it is inevitable that they would be reliant on public funds, both for their accommodation and their maintenance. Paragraph 4.
Why do you say that? Would they not be able to work in this country?
No, they. No, I. No, the sponsor, my lord, is unable to work, and the sponsor is reliant on public funds.
I understand that.
And
But if the respondents are permitted entry to the UK, obviously the little children will have to rely on other people to support them. But why couldn't the adults, in principle, support people without recourse to public funds? I mean, you may be right. I'm just asking.
yes, yes. Yes, I think that the judge was making the point that, well, one of the respondent was seriously unwell.
Yes.
And the finding is that they are likely to be reliant on public funds. But of course, I accept that there is, if they are granted leave, there is a possibility, of course, that sisters would or could find work. Whether that is going to be easy or practical is a different matter,
Yes.
in the light of the fact that they do not speak English.
Yes.
But these are matters that undoubtedly go in the Secretary of State's favor, and the judge was doing the right thing.
Yeah, and she said, I attach a great deal of weight.
So no issue with that. But you have my submissions on paragraph 36. So the judge then identified matters that are in favor of the respondents. And she's conducting the balance here, but in my submission, having made a fundamental error, the balancing exercise is flawed. The error being that very considerable weight isn't attached to the Secretary of State's policy. But if you look at the matters that the judge placed weight on, you'll see that just like the Upper Tribunal in IA and others, the focus really is on the circumstances of the applicants abroad, as opposed to on the sponsor. The very first point that the judge makes, paragraph 40, is that the sisters were threatened with forced marriage, and the father had to leave Afghanistan. The sponsor was stabbed, and they were facing very difficult circumstances. The next point is also focused entirely on the applicants abroad. They are outside the jurisdiction of the convention, outside the UK. The second point is that they live in a very precarious situation. They are living without lawful status in Turkey, may be deported to Afghanistan. All that is correct, and that is extremely stressful, frightening. No one would dispute that. But this is the same error the Upper Tribunal made in IA and others, focusing on the rights and circumstances of the applicants abroad.
Well, this may be right, but I'm finding this quite difficult to conceptualize, because I have in my mind the analogy with the 1930s, which is the origins of all of this law.
Yes.
So the sponsor is in the UK, having managed to flee Nazi Germany.
Yes.
And what are we supposed to do? Not take into account that his family are in real danger
So this is
in Nazi occupation? What are we supposed to do? Just ignore that those are the realities. That's the whole point of saying that. That's why they need to be able to join the sponsor here.
So, yeah, I mean, that was the discussion in I and others.
Oh, I see.
Whether you use Article 3 jurisprudence, the Refugee Convention jurisprudence,
I see.
as a backdoor to allow family members to use Article 8 to enter the UK. So, my lord, the circumstances deserve careful consideration, utmost sympathy. But the message from I and others is quite clear, that these are matters that are not directly relevant when it comes to Article 8 because of the nature of the Article 8 exercise.
For the purpose of this analysis, we have to assume that there is family life.
There is family life, yes.
So that we're dealing with proportionality here.
Yes.
So how would it work, say, if they were young children who have been left behind in Germany, and the sponsor has managed somehow to escape and get to the UK,
Yeah.
and now says, I want to be rejoined. So there's undoubtedly family life. But is the effect of IA that we can't take into account what's going to happen to children who are left behind?
No, IA does not go that far.
I see.
And it's not my submission that these matters are left completely out of account. So the words that, as I emphasized, were used in I and others was, what is the focus of the fact finder? Is the focus on the difficulties that a family faces in war zone, Gaza, Afghanistan, or is it the sponsor, the jurisdictional peg by which Article 8 is engaged is the presence of sponsor in the UK. Now, the example Lord Justice Singh gave, if separation is affecting such an adverse impact on a person who is in the UK, that would render separation disproportionate, then there is, of course, a possibility that the appeal is allowed. But the question again is where the focus ought to be.
Yes. And none of this may arise if you don't get past grounds 1 or 2 anyway.
Yes.
Right.
So the first 2 points that judge makes are focused on the difficulties abroad. The third point, paragraph 42, it concerns the welfare of the 2 children. And the judge says that it is contrary to their best interest that they stay in Turkey. This was dealt with again in I and others. The welfare of the children is relevant, but it can only override the public interest in very compelling or exceptional circumstances. Very compelling or exceptional circumstances. Paragraph 43, the judge says, the reference to Miss Tariq, I think it's a typo. The judge says that it is correct. The judge says essentially that the status quo isn't appropriate. The fact that they are able to speak remotely isn't a substitute. And the judge then considers medical evidence, and the conclusion reached is at paragraph 47 that there is no other option. They have to come to the UK. They cannot stay unlawfully in Turkey. They cannot go to Afghanistan. But that, with respect, would be true for any family in a war zone. and there is no positive obligation, as IA says, to allow family members to join other family members in the UK. And the judge says, in conclusion, that the decision is disproportionate, does not apply the very exceptional compelling circumstances test, attaches no or too little weight to the public interest, and in my submission, erred in holding that the decision, the interference, is disproportionate. Lord, it was agreed between counsel that I will have until 1 p.m. for my submissions, but I think I have made all my submissions on the 3 grounds. So unless I can assist you any further, these are my submissions.
I don't detect any more questions, so thank you very much, Mr. Malik. Mr. Chair,
My lords, thank you very much. Let me just get my papers in the right place. Your lordships should have 2 family court authorities. I'll address those when I come to speak about ground 2. They're to do with the approach that this court should take when it looks at an upper tribunal or a lower court decision where the law has subsequently changed, or the law's changed or has been clarified in between the upper tribunals. So I'll come to those probably after lunch. I act, of course, with Ms. Turnbull for the respondents to this claim. As you know, the first respondent very sadly died earlier this year, as Mr. Malik Casey said. His son, the sponsor's in court with Mr. Perkins, his psychotherapist and support worker. You'll have seen him at the back of the court. Mr. Malik for the ECO challenges each aspect of the Upper Tribunal's decision making. So firstly, its decision to set aside First-tier Tribunal's decision in turn. Secondly, its own conclusion that Article 8 had engaged. And thirdly, its decision on proportionality. We say that in all 3 of those respects, the Upper Tribunal was right and acted in accordance with the law. The first 2 grounds raise the question, as my lords have observed, an overlapping question, the underlying question is whether the sponsor enjoys family life with his family, with the respondents, in the meaning of Article 8. Sorry, I'm losing my voice. So our case, just in summary, is that on ground 1, which is about whether the First-tier Tribunal erred in law in finding no family life, we make 2 points. Firstly, that the First-tier Tribunal applied materially the wrong test, not because it directed itself in accordance with Gagarthas, but because it required the respondents to show more than the law requires. It required them to show more than something additional to normal family life. It required them to show something additional to abnormal family life, abnormally strong family ties, I should say. And that, without more, that's the error which the Upper Tribunal, we say, correctly identified. And that, without more, was sufficient to require that the First-tier Tribunal's decision be set aside and to justify the Upper Tribunal in setting it aside. Secondly, we say additionally that the Upper Tribunal was right to hold that on the FTT's own findings, its conclusion that there was no Article 8 family life between the sponsor and the respondents was perverse. But of course, we don't need that if we succeed on the question of the wrong test. As for ground 2, we accept, of course, that when the Upper Tribunal considered the family life question for itself, it framed its analysis by reference to a question, the real, effective and committed support question, which was not the ultimate question it was required to ask or to answer. IA and others have made that clear, so we accept that it was wrong in doing that. But we say it's necessary to read the Upper Tribunal's decisions fairly and as a whole, taking into account the fact that it was addressing the law as it was understood before the clarification in IA and others, And we say that when the Upper Tribunal's decisions are read fairly and as a whole, its erroneous understanding of the law is immaterial because, firstly, because in substance it also answered the correct question. It also plainly found that there were additional elements of dependency over and above the normal emotional ties between adult family members. Not only that, but we say that the second half of paragraph 33, that's the section where, which you've just spent some time with Mr. Malik, and I'll take you back there later on. We say, contrary to what Mr. Malik suggests, the second half of that paragraph is absolutely clear. The Upper Tribunal, when it was considering in the alternative whether it might be wrong about what Kamari meant, it then applied a test which was significantly more favourable to the Secretary of State or to the ECO than the correct test, and made a finding that the respondents met that test. Mr. Malik ultimately argued that conclusion was perverse. He doesn't have permission to argue that. But in any event, we say it plainly wasn't perverse. It was fully reasoned. It was clearly founded on the evidence which was before the Upper Tribunal, and it demonstrates it makes absolutely clear that the Upper Tribunal had not only the correct test in mind, but in fact an even higher test in mind than the alternative. But I will take your lordships through Iron and others. I'm sorry that you will have to trawl through that, or I will invite you. So you don't have to do anything, do you? But I will be inviting you to trawl through that again. To identify some other features of it, which maybe didn't emerge from Mr. Malik's submissions. But we say that the two questions, real and effective and committed support and additional elements of dependency over and above normal emotional ties, they're not mutually exclusive questions. The Court of Appeal itself recognised that there may be significant overlap between them. And because we say that the Upper Tribunal made no legal error in the test it applied, there's no basis to set aside its decision about family life. My learned friend makes two further points about family life in paragraphs 29 and 31 of his skeleton argument. I'll deal with those in turn, but we say they're ill-founded and they identify no legal error. So we say that the Upper Tribunal's finding about family life was both correct and sustainable. Finally, on ground 3, that what the ECO argues in my learned friend's skeleton argument is that the Upper Tribunal's assessment of proportionality cannot stand in light of IA and others. That's the way in which he puts his case. We say that there is no legal principle properly derived from IA and others with which the Upper Tribunal's decision is inconsistent. Secondly, we say that insofar as the ECO, as Mr. Malik, is seeking to draw factual precedent from the IA and others' decision, firstly, that's an illegitimate exercise as a matter of principle, and secondly, it's an exercise that doesn't work on the facts, given the very clear factual differences between this case and the case considered in IA and others. And finally, my learned friend makes much of what he says is the Upper Tribunal's failure to direct itself to the importance of immigration control and the very significant weight and so on. We say that if you read the judgment of the decision of the Upper Tribunal as a whole, it's perfectly plain that it attached very significant weight to both the need to enforce immigration control and to the question whether a case fell within or outside a policy. That's absolutely clear from the final paragraph of its decision. But we also say that in stark contrast with the case of IA and others, and it was said repeatedly in IA and others that the Secretary of State and the court took the point that there was no resettlement policy relating to Gaza. In this case, there is a policy which is referred to, it's set out at length in the Upper Tribunal's decision. It's not a resettlement policy, it's a policy for grants of leave outside the immigration rules. My learned friend's entirely silent about that. But that fills, even if you thought that the Upper Tribunal had to say more to demonstrate that it was attaching significant weight to the need for immigration control, then it does that. fills that gap by citing a relevant policy and explaining why this case is, making clear why this case falls within the policy. So again,
I don't understand that submission, I'm afraid, because there's always that residual discretion to grant leave outside the rules.
my lord, that's right. But there's a policy which sets out the circumstances in which medical conditions can. I will take your lordship's there later, but if I just turn it up.
Don't take it out of turn.
No, but so we'll say it may or may not be. I recognise, of course, there's always a residual, but we say there's more than that here. That there's a policy which refers to sponsors, people in the UK who've come to the end of the medical support that they can get in the UK and who won't get better without family members being here. Just to paraphrase the policy rather. And we say that was the immigration. That's the Secretary of State's policy, which the Upper Tribunal properly had regard to, and of course it distinguishes this case from the IA and others' case. I will come back to it when I'm dealing with ground 3. So we say for all those reasons, the entry clearance officer's appeal should be dismissed on all grounds. Just in terms of what should happen if we're wrong about that, plainly if we're wrong about ground 1, subject to if we're wrong about 1, we would say that the First-tier Tribunal's decision should simply be reinstated. There's no need for you to remake a decision. We would accept that if we're wrong, and the only legal error is that in the First-tier Tribunal's decision was that it had directed itself to the Kagarthas version of the test, then that would be an error which would require the setting aside of the decision and its remaking. And I agree with what my learned friend says about the Tribunal Courts and Enforcement Act. You have the power not to set something aside if nothing's going to be gained. And we would invite you not to embark on the exercise of remaking in those circumstances. If we're wrong about, if we succeed on ground 1, so the matter was properly before the Upper Tribunal, but we lose on grounds 2 or 3, then we would be saying this is a case that should not be that my lord shouldn't remake. And I'll expand on that a little bit at the end. But there are clear distinguishing features from IA and others. IA and others was a case in which a major point of law was being redecided. So it potentially, and it's framed very much within the Schwidler framework of a case where a proportionality or guidance was being given about proportionality, which might bear on other cases. I recognise that only relates to the proportionality exercise. It doesn't answer my lord's question about remaking the decision about whether family life is established. But there are 2 differences. Maybe if I say this now, it'll save me having to come back to it at the end. Firstly, and this is partly in answer to my Lord Justice Baker's question before, there was no... The IA and others case came before this court in rather peculiar circumstances. As you have seen from the end of the judgment, the Secretary of State had conceded the grant of entry clearance. Mm-hmm. And so it came to this court with Hutchison and Popdog protection, so that the respondents in that case were protected by an indemnity cost, a prior indemnity costs order. They had no interest in the outcome of the case. There was nothing that could be remitted back to the Upper Tribunal because there was no prospect of them producing updating evidence. Here, plainly, this case is distinguishable on that ground. It's also distinguishable on the basis that, for the sad reason that there's been an obvious and very significant change in circumstances in these family, and because your job would be to be remaking. So in I and others, there was no change in circumstances. There was no prospect of any evidence of change in circumstances. In this case, there plainly has been a change. And we'd say that it would be for the Upper Tribunal to hear evidence again and remake a decision in light of
If
that.
you're right about that, would you invite us to remit to the FTT or to the UT?
We would invite you to remit to Judge Bruce, because the reason, if your finding was that what Judge Bruce had done was that she had applied the test, and I'll come back to the adoption cases, but if what Judge Bruce has done is considered the evidence but applied the wrong test, there's no challenge to any of her primary findings of fact, then it would be appropriate for her to hear the case again and simply direct herself in accordance with the law. That would be our first submission. Of course, my Lord Glass, I will.
You'll develop that in due course.
I will develop it. I understand why that. In circumstances where we would get to this stage if you thought that there were, if you thought that the only error were the application of the wrong test. Plainly, if your finding was that there were additional errors, then that would be a reason. That would potentially be a reason not to remit.
So the logic would be that Judge Bruce had been right to set aside the first-tier tribunal,
yes.
therefore right to embark on the remaking.
But had directed herself in accordance with the law as it was then understood.
So there would be a logic in doing the remaking again.
So if she'd been right to set aside the FTT, both applying the wrong tests.
Yes. So my Lord, do you have quite a discretion about that? Well, I'm simply, since you've asked that, we would say that was the appropriate thing to do if your finding was that what had gone wrong was that Judge Bruce had applied the wrong test. Were that not to be the case, then I haven't got instructions. I maybe haven't thought very hard about whether it should go, if it were going to a completely different tribunal, whether it should not in fact go back to the First-tier Tribunal, so that in that case everyone could remake decisions in accordance with the correct law.
Mr. Cherrick, I think certainly before you sit down this afternoon, you will at least hypothetically have to address us on another scenario, which is, I stress, we have no views.
Yeah.
We don't know what the outcome is going to be. But if we end up concluding that Mr. Malik's ground 2 is made out, and so the UT misdirected itself in law in the light of IA, then we might take the view that we have all the primary facts that we need, and we reach the conclusion that this is not family life. So in other words, we don't remit. We make that decision for ourselves. Now, I think you at least have to contemplate the possibility that we might take that course. So I think you'll have to address it.
So my Lord, I contemplate that possibility, and I would address you on it. But my starting point is that it is an extremely artificial exercise for me to do that, not simply because I'm addressing you on the basis of evidence you don't have. So the Secretary of State has seen some evidence about changes in circumstances. You don't. It's not before the court.
What is the date? What is the point at which we make that evaluation? Now.
Yes.
Well, there's obviously been at least one development.
There is a very significant change that developed here, and
the death of one of the respondents.
The death of the only male respondent in the family unit in Turkey. My Lords, I would make a submission to you, and maybe this is the way I should deal with it. The way I would probably end up doing this is making submission to you as to why we say that on the facts as found below, there was already family life at the date of the Upper Tribunal's decision. And that's the submission I think I'm not able to address you properly on what's happened since then. It's safe to say that our submission, I anticipate, would be, if this was remade in light of that evidence, that the family life has become stronger. But I will certainly think about that over the lunch break and recognise what my Lord's asked. Can I just make one final point, which is an obvious one? It's clear that everyone has sympathy for this family. My learned friend has said that, and we recognise that, and so have all the judges determining this. And it's common ground that Article 8 isn't a dispensing provision. Article 8 doesn't require or permit grants of leave to remain simply because circumstances are sympathetic or compassionate. But it is important, we say, not to overcompensate in the opposite direction. And there's nothing suspect about a claim which evokes sympathy. It's simply necessary to determine objectively whether it falls within Article 8. And we say that there can be a risk, and we say that's slipped into some of my learned friends' submissions, that what happens is that in cases which are sympathetic, for example, cases where family members have been separated in traumatic circumstances, where what we're invited to do, what the courts are invited to do, is to impose higher thresholds. For example, higher thresholds in determining what are additional elements of dependency over and above normal emotional ties, or what are normal emotional ties. there's a risk that we're invited to impose higher thresholds than we would in cases which were less sympathetic. And that is, as we say, as a matter of principle, that's as objectionable as inviting a court to grant to allow an Article 8 claim because it feels sympathetic. Neither would be correct. So, my lords, I'd like to start by taking you through, I'll try and do this fast, but I'd like to take you, if I may, through a series of background Article 8 cases, then take you through IA and others, and then possibly, well, as quickly as I can, take you through our responses to the three grounds, if I may. So can I start in the authorities bundle? And we say that in order to put the IA decision in context, it's important to go back to Article 8 principles, and so I'll do this fast because I'm very aware that your lordships are familiar with many of these cases. Can I start in tab 6 of the authorities bundle? It's the Singh and Singh case, but I'm taking you to it for another authority, very well-known authority cited in it. It's Rasgar, so it's tab 6, page 90, paragraph 18, Lord Bingham's judgment in Rasgar. Just as a
sorry, which paragraph?
My lord, sorry, it's paragraph 18 on page 90 of the authorities bundle. In fact, it's Rasgar as cited verbatim by Lord Justice Sedley in BW Uganda.
Yeah.
So I'm relying on both Rasgar itself and then the comment on it by Lord Justice Sedley. Very familiar to your lordships, the 5-stage Article 8 test. I'm only including it because it's important to keep the different stages of that inquiry conceptually separate, and in particular not to allow questions relevant to proportionality to infect the question whether family life is established in the first place. So questions 1 and 2 relate to the engagement of Article 8, and 3, 4 and 5 relate to justification for an interference. But 1 and 5 is there a family life which will be interfered with, and 5, is the interference proportionate, have to be kept. They're at opposite ends of that series of questions for a good reason. And we'll say that some of my learned friends' submissions about the existence of family life are really, and particularly in the written arguments, really go to the question of proportionality and not to the existence of family life. And then the second point made there is that there isn't a question before your lordships about whether this decision interfered, but Lord Justice Sedley's comment on the second Rasgar question is important. At the bottom of page 90, consequences of such gravity simply requires more than a technical and inconsequential interference, and there's no dispute that if family life's engaged, the refusal of entry clearance to this family is more than technical and inconsequential. My lords, the next authority, again, I'm looking at it through another. So this is in tab 7 through Hesham Ali. And looking at the judgment in Huang, so which my Lord Lord Justice Singh will remember well. So this is tab 7, page 46.
Internal.
So, sorry, page 117. I'm so sorry. It's paragraph 46. Tab 7, paragraph 117. Page 117, paragraph 46. So this is Hesham Ali post new statute, or sorry, post new rules, referring to series of older authorities. And maybe go back, if I may, sorry, to page 116. So it's been the law since, or been clear since Huang, page 116, paragraph 41, that the failure to qualify under the rules is the point at which to begin, not end consideration of the claim under Article 8. That's clear. The terms of the rules are relevant to that consideration, but they're not determinative. So that's reapproved in Heshmali in the context of deportation. And then paragraph 44, giving of weight to factors, so again, it's the quote from Huang, giving of weight to factors such as these, and those are the Secretary of State's policies, is not described as deference. It's performance of the ordinary judicial task of weighing up competing considerations on each side, according appropriate weight to the judge, the personal responsibility, and so on. And then so we accept that the starting point for consideration of any claim which is outside the rules is that weight will be attached to the Secretary of State's judgment about the limits of immigration control. So that's common ground. We say that that's common ground, which firstly is codified in Section 117B of the 2002 Act. I don't need Mullins to turn that up, but it's...
Jericho, sorry to interrupt you. When Lord Bingham gave his opinion in Huang,
Yes.
he used the language, if I recall correctly, of appropriate weight.
Yes.
And that's replicated in the second line of paragraph 44
Yeah.
of this citation in Hishanabi. But at some point, the case law seems to have moved on. And now we've certainly had a lot of emphasis placed on the phrase considerable weight.
Yes. Well. So we accept certainly for these purposes that considerable weight has to now to be placed. That's the consequence. That's the effect of has to be, and whether the reason for that is the fact that since 2012, and therefore by the time of Huang, the Secretary of State has formulated rules which are expressly intended to generally to set out the limits of Article 8, when that wasn't the case as at the time of Huang. But I accept, sorry, I'm not trying to make a point about appropriate weight. I'm not suggesting that there's flexibility on that. I accept that considerable weight is attached. That's the consequence as well of Section 117B. I'm slightly... So while we're in Heshmali, can I then ask you to turn up again another judgment through it? So this is on page 145 of the authorities. This is the case of E.B. Kosovo, another judgment of Lord Bingham, again very familiar.
Sorry, which paragraph?
Sorry, it's paragraph 159 on page 145.
Yeah, thank you.
And its emphasis on, I recognise this can cut against me on the Secretary of State's ground 1, but for us on 2 and 3. The appellate authority must make its own judgment, and that judgment will be strongly influenced by the particular facts and circumstances of the particular case. It's paraphrasing something that the House Lord that Bingham had already said in Huang. The authority will, of course, take note of facts which have or have not weighed with the Strasbourg authorities, but there is in general no alternative to making a careful and informed evaluation of the facts of the particular case. The search for a hard-edged or bright-line rule to be applied to the generality of cases incompatible with the difficult evaluative exercise which Article 8 requires. And we say that's the backdrop to IA and others. While the Court of Appeal gives strong guidance in IA and others, it doesn't seek to impose bright-line or hard-edged rules. And that's a point I'll seek to make good when we get to that. Also in Heshmali, this is from the Heshmali judgment itself, it's page 113, paragraph 32, and it goes to a point that my learned friend hasn't developed.
Sorry, where are you?
Page 113, paragraph 32. I'm sorry to jump around, my lords. It's an easy way of finding 3 different cases in behind one tab.
Yeah.
But so page 113, paragraph 32, and this is this is Lord Reid developing a conclusion which was first reached by Lady Hale and Lord Wilson in the Keeler case. Don't need to take you, it's not in the bundle, and we don't need to go there, but whether the situation is analysed in terms of positive or negative obligations is unlikely to be of substantial importance. And the question arose in deportation cases because it was being suggested if someone had no right to be in the UK, what he or she was requesting was a positive act, the act of granting leave to remain, and so was relying on positive obligations. There was support for that in older Strasbourg authority, but in line with the Keeler case, Lord Reid in Ali says, at the bottom, that the last two paragraphs, so starting sideline between D and E. So the Secretary of State has said the onus is on the state to justify an interference, whereas there is no such onus on the state to demonstrate the absence of a positive obligation. So the Secretary of State was submitting there's no difference in what's required to justify a breach of a positive obligation and a breach of a negative obligation. But Lord Reid says questions of onus are unlikely to be important where the relative facts have been established. Ultimately, whether the case is considered to concern a positive or a negative obligation, the question is whether a fair balance is struck. It's back to the Huang that strike the fair balance.
Just before you go on, did you refer to underlining there or sidelining?
Sorry, not sidelining. I referred to. I probably used the wrong word. It's side. It's D and E. I don't know what we call those side reference. Are they side references?
No, I see. No, I just thought that my copy might be missing.
No.
Sidelining, but that is.
I'm afraid I have a very scrawled sideline.
No, that's
my own.
fine.
You don't have that.
I was only worried in case.
I meant letters. I'm so sorry.
Yeah.
Right. So, and I
So
referred.
just before we leave that
Yes.
paragraph, I can understand the point that's being made that it doesn't really matter if you analyse it in terms of positive or negative obligations.
Yes.
But that's in the context of a deportation case. Might it matter more in a case like the present, where what you need to succeed is a positive obligation on the state, the United Kingdom, to permit people who are outside the United Kingdom to come into the United Kingdom when they have no other legal right to do so?
My lord, yes. So Keeler, which is where it's, I'm sorry. Maybe we should have put more authorities in, but Keeler, which is where the question of the difference between positive and negative obligations arose and was decided by, not that it didn't arise for the first time, but was decided in the Supreme Court, was an entry clearance cases. Those were cases about the raising of the marriage age from 18 to 21. And it was in that context that the Secretary of State was relying on the Abdulaziz judgment, and both Lord Wilson and Lady Hale said that it was time to put that distinction, to consign it to history, I think was the phrase that Lord Wilson used. So that was in the context of entry clearance. But my lord, in answer to that question, can I take you to with the next paragraph I was going to take you to, which is in Hesham Ali. It's on page 118, paragraph 50.
Yes.
I'm so sorry. That's not. No, I've jumped too far. It's 49. So it's at the time of striking the fair balance that relevant differences between, for example, deportation, expulsion, or admission can be taken into account. So I accept that those, for obvious reasons, a person who's seeking admission to the UK may not be able to rely on the solidity of his or her ties in the UK. That's going to be different. But the differences between different types of Article 8 claims are to be dealt with on a case-by-case basis within the fair balance exercise, and not by a hard-line distinction between positive and negative obligations. That's my lords. That's the only point I'm trying to make. So I accept, of course, that there will be differences between different categories of cases, but they're dealt with through the fair balance exercise, not through bright lines. Sorry, the next case I was going to take you to was at tab 5, EM Lebanon. Again, a case, my lord, Justice Singh was in that one as well, I believe. And that's a case about the nature of family life. So the main issue in the case was the threshold of harm that had to be. It was a case about a Lebanese mother and son who had claimed asylum unsuccessfully in the UK, and they faced removal together to Lebanon. The evidence was that that the consequence of that would be that the child would be taken away from her and given into and passed on to the father's family. So the main issue was the threshold of that was the flagrancy test, the threshold of harm, which had to be met in a wholly out-of-country Article 8 claim. But one of the issues which was raised was therefore what are the core values which Article 8 is designed to protect. So if in order to succeed on that kind of Article 8 claim, I have to show an interference in a core value. What are those core values? And Lord Bingham addresses that question from page 73 onwards, paragraph 36. And the case starts, the paragraph 36 starts with references to the importance of parent and child contact. And of course that was the kind of family life which was under consideration in EM. But then Lord Bingham refers back to his Huang judgment, and that this is a quote. It's the basic explanation of what Article 8 is designed to protect, which I'm going to keep coming back to. So human beings are social animals; they depend on others.
Sorry, where are you reading from?
Sorry, my lord, it's the bottom of page 73.
Sorry, I'm in the wrong place. Thank you.
No, I'm sure it's me. So it's bottom of page 73. Human beings are social animals. They depend on others. Their family or extended family is the group on which many people most heavily depend, socially, emotionally, and often financially. So that's dependency. There comes a point. The whole of this. People, family members are people upon we depend, socially, emotionally, and often financially. And then there comes a point at which, for some, prolonged and unavoidable separation from this group seriously inhibits their ability to live full and fulfilling lives. And we say, just reading that together, and reading that now through the lens of later decisions, if I can show that the prolonged and unavoidable separation from a person, a family member, seriously inhibits my ability to live a full and fulfilling life, that's a strong indicator that that's a person upon whom I heavily depend, or most heavily depend, socially, emotionally, and often financially. It's a good guide, we say, to. It's not. We wouldn't say it's a necessary condition, but if I could show that prolonged and unavoidable separation from a group seriously inhibited my ability to live a full and fulfilling life, it would be difficult to say that I didn't have dependency for purposes of Article 8. And then moving on, paragraph 37, what is a family? Families differ widely in their composition, and this is still good law, of course, in their composition and in the mutual relations which exist between the members, and marked changes are likely to occur over time within the same family. So that's a recognition that the fact that family life may be interrupted for a while doesn't mean that it can't be revived. But also that the interrelationships within a family may change. Thus, there is no predetermined model of family or family life to which Article 8 must be applied. The article requires respect to be shown for the right to such family life as is or may be enjoyed by the particular applicant or applicants before the court, always bearing in mind the participation of other members who share in the life of that family. And that's the Bioku Bet. That's back to Bioku Bet, which had been decided slightly earlier that year. And then 38 addresses the very specific question. If you're relying on no Article 8 rights in this country and you're simply relying on the consequences outside the country where it's a qualified right, how do I demonstrate that I've met the flagrancy test? We don't need to worry about that in this context. The final point I'd like to take you to in EM Lebanon is paragraph 40, because again we say this casts some light on what we will say the First-tier Tribunal did wrong and the Upper Tribunal did right. It's no doubt a feature. So this was a mother and child who were likely to be separated if they were returned to Lebanon under Sharia law, they're likely to be the findings below. It's no doubt a feature of their family life that the appellant renders for the child the sort of services which a mother ordinarily does render for a growing adolescent. But it would be wrong to regard the relationship between the appellant and heir as simply one in which the mother renders services for the son. The evidence makes plain that the bond between the two is of deep love and mutual dependence. So what is family life here? The essence of family life is not services I provide, help I provide, things that I do for someone, because anyone can do those things. If that was what family life was, then you could replace mum with someone else. And this is not going to come as any surprise at all within the context of family life. The bond, which is the family life bond, is one of deep love and mutual dependence. Now, of course, that's in the context of a child, mother and child relationship, where dependency is assumed. But it casts light on what's said above about there being no predetermined model of family or family life, and above that again in Huang about being seriously inhibited in my ability to live a full and fulfilling life. That's the backdrop. Can I take you then to, it's the case of, it's tab 8. Sorry, it's not. It's tab 6. It's the case of Singh and Singh. So these were two brothers who were, Vikas Singh and Manish Singh, who were adults who had come to the United Kingdom to join their mother, and on the findings of the tribunals below, they didn't enjoy family life with their mother, largely because she was mainly outside the UK. And it's relevant for its assessment of, we say, the reason I'm referring to it is what Sir Stanley Burnton says about family life between a child who passes the age of 18. So this is one of the models. It's a person who passes the age of 18, does family life extinguish, or presumptively extinguish even when that child ceases to be a child. And so if I could just take you to some of the authorities. So a large part of this judgment consists of a review of domestic and Strasbourg authorities. The court's ultimate conclusion was, and this is, I don't need to take you to it, but 25 was that even if there was an error in even if there had been an error in finding only private life and not family life, that was immaterial, because in a removal case, the court would adopt the same approach, the same balancing exercise would take place either way. But we know that's not true in entry clearance cases. Entry clearance cases only engage Article 8, as we understand the law at the moment in any event, if there's family life, with some very rare exceptional circumstances. One example was the case of Ali last year. But generally speaking, entry clearance case, the jurisdictional peg only exists when there's a family life claim. But in this case, that wasn't true. What I'd ask you to look at is firstly Lady Justice Arden's, so page 86, paragraph 11, quoting from Pigathus, and I'm not taking you to Lord Justice Sedley's decision, which is criticised to some degree, but to Lady Justice Arden making clear that there is no presumption of family life. It's not, as I said, paragraph 25 in the quote at paragraph 11 of Singh and Singh, bottom of page 86. Family life is not established between an adult child and his surviving parent or other children unless something more exists than normal emotional ties. It's exactly the test that we all now know well. Such ties might exist if the appellant were dependent on his family or vice versa. It's not, however, essential that the members of the family should be in the same country. So that was one of the, and that's not disapproved. So again, just a reminder that being in different countries doesn't mean family life has been extinguished. Then page 89. This is the Strasbourg authority, it's the Strasbourg case of AA and the UK. It was a deportation case. A young man who'd been convicted of rape as a child now becomes an adult. And at the top of the page, we can see that the Strasbourg court gave examples of two cases where a court had declined to find family life between an adult and his parents. The two examples, one of them had ceased to cohabit, the other had not. But the bottom line, it's noteworthy that both applicants had a child or children of their own following relationships of some duration. So that will be a factor which would tend to lead, we say, a court to find that family life had broken down. It's the situation in IA and others. Both the brothers had children. And then paragraph 48 within that judgment. On the other hand, if an applicant was single and had no children, in the case of young adults who had not yet founded their families, their ties with their parents and other close members could constitute family life. So it's the kind of circumstance in which a child who becomes an adult will lose or may lose family life, as if he or she leaves the family and goes off and starts a family with someone else. But if that young adult hasn't yet founded their own family, their ties with parents and other close family members would constitute family life. Another example, it's page 92. That's the case of AP. So it's paragraph 23, quoting from AP India, Lord Justice McComb's decision. And these are children who start using, adult children who start using home as a base, and who go off to university and go off and do things, but they gravitate towards their homes during holidays and upon graduation, while they seek to make their own way in the world. Such a child is very much part of the ongoing family unit, and until such a child does fly the nest, his or her belonging to the family is as strong as ever. That's a test. Has this child flown the nest? And we say, and I'll preempt this submission I'm going to make, that leaving your family because you're fleeing persecution, not as a matter of choice at all, isn't flying the nest. That's not what's had in mind here. That's a decision to go out and build up your own life. That's not the kind of circumstance which the Strasbourg court has in mind there. So there are no hard and fast rules, but those are illustrations of the kinds of factor which might be relevant to an assessment of whether family life is broken down. The reason that I linger on that a bit is because we say, and it's accepted, so the First-tier Tribunal accepted that family life had persisted while the sponsor turned adult, or he turned 18 while he was still in Afghanistan. There was no cut-off of family life. The question is whether when he fled Afghanistan, or when he fled his home to Kabul and then fled Kabul having been stabbed there, whether that cut family life off. Again, I'll come back to that in the First-tier Tribunal's decision. My lords, there are two more authorities before I come to IA and others, if I may. First, they're two Strasbourg authorities. First one is Tekwabo Tekle. So that's at tab 13. And Mr. Tekwabo Tekle was a child still when she made an application. So her mother had fled Ethiopia and had ended up in the Netherlands, residing there with children in the Netherlands. She had left her daughter behind in Ethiopia, and her daughter was being looked after by other family members. And about 8 years later, just looking at the date, she applied for her daughter to join her. By this time, her daughter was about 16, to rejoin her or to join her in the Netherlands. So there are obvious differences. It's a case about children. Family life was assumed. There was no question about whether family life existed. What is relevant is the question whether the mother could be said to have broken family life by fleeing Ethiopia. And so if I could ask you to look at page 266 within this judgment. And you can see it's in the middle. This is the Netherlands submission. So the state party said, or relied on what they said were the fact that the mother had left the daughter behind in the care of her grandmother and uncle, so behind in Ethiopia, of her own free will, and had come on to start a new family with a husband in the Netherlands, with a new husband in the Netherlands, and that the daughter left behind had never been part of that family, nor was she exerting any authority over her daughter. All she was doing was sending money. So you see that from 38. And when the court goes on to consider that, another point, that it was not suggested that the daughter was at risk or that she couldn't be looked after. There were relatives looking after her at Ethiopia. You see that in paragraph 50 on page 269. And what the court, so page 268, paragraph 47, would the daughter settling in the Netherlands be the most adequate meet for family life to be developed together? And the court in Tukwabo Tekle compared her situation with the situation of the family in Shen in the Netherlands. That was the first entry clearance case, which had succeeded on Article 8 grounds, on pure Article 8 grounds in Strasbourg. And so you see the summary of that case had concerned parents with settled immigration status in, so this is the Shen case, with settled immigration status in the Netherlands who had chosen to leave their daughter behind in the care of relatives in Turkey for a number of years before they applied to be reunited. Now, that was a free choice. And the Strasbourg court interposes, we would remark that it is questionable to what extent it can be maintained in the present case, as the Netherlands government had done, that the mother had left the daughter behind of her own free will, bearing in mind that she'd fled Eritrea, sorry, I've said Ethiopia over and over again, it's Eritrea, in the course of a civil war to seek asylum abroad following the death of her husband. That's not free will, that's not a decision to separate. But in any event, even if that wasn't right, both the mother in the Tukwabo Tekle case and the parents in the Shen case had been lawfully residing in the Netherlands for a number of years and had built up ties in the UK, but then, back on page 268, paragraph 45, 6 lines down within 45, the court has previously held that parents who leave children behind while they settle abroad cannot be assumed to have irrevocably decided that those children are to remain in the country of origin permanently and to have abandoned any idea of a future family reunion. We say that's the same. If you've established...
Sorry, I've lost you.
I'm so sorry, I'm trying to speed up. That's page 268, paragraph 45.
And where were you reading from?
I'm reading from 6 lines into that paragraph.
I see, yes.
So the Netherlands is saying, if you'd really wanted your child to be with you, you'd have applied sooner. And the court says, but you can't assume, it can't be assumed that if parents leave a child behind, that they have irrevocably decided that they're to remain permanent. And we'd say the same is true. If a 18-year-old flees Afghanistan without knowing when he's going to see or whether he's going to see his parents again, it can't be assumed that he or they have irrevocably decided that the family life should be broken on that basis. I'll come back to that again in the first decision. And then the final case is Kamari. You've been taken to it through IA and others by my learned friend. The judgment's in full at behind tab 14. The relevant section is, and I'm not going to repeat what you've already been taken to, but the relevant section is at paragraph, on page 282, starting at paragraph 34. And so here we've got paragraph 34, essentially a question of fact, so no bright line rules and no factual precedents, we say. It's the consequence of that. 35, that's the test that we all know is, in light of I and others, is the correctly worded test. Paragraph 36, there is an exception for young adults who are still living with their parents and have not yet started a family of their own. And the reason why is that in that particular situation, that's towards the bottom of 36 after all the quotes, in that particular situation, dependency is assumed. So the starting point is an assumption of dependency. If there's still cohabitation and no separate family. 37, again, case-by-case basis. And then the case law examples which are provided below by way of further clarification. My submission is that my learned friend is seeking to read more than can be read into the examples which are provided by way of clarification. They don't establish factual precedents. They can give some insight into what Strasbourg has done, but they don't and are not intended to establish factual precedent. And the other point I would like to make about Komori is that you see from, so I'm sorry, I'm going back to 35, but it really probably doesn't matter which paragraph I'm in. These examples which are given are not all immigration examples. They're to do with whether family life. So, for instance, the Eminette case, which is referred to at the bottom of 35, is an adoption case. And it would be wrong, and this is a risk, and it goes into what we'll say about the Secretary of State's Ground 1. It would be a risk to look at what a normal emotional tie is always through the lens of immigration cases. When the Strasbourg court talks about a test which involves more than the normal emotional ties, it's looking at the normal emotional ties between any two related adults.
Sorry, between
any two related adults. It's not looking at the normal emotional ties between the ties which would be normal between the two adults who've been separated by one having to flee another country, nor even the normal emotional ties, nor the emotional ties which would exist between a person and their mother for whom they're a primary carer and so on. Just looking at the starting point is what are the normal emotional ties between any two adults, and is there an additional element of dependency over and above those? The test is applied to all relationships between adults, not only in the immigration context. My lords, that's the end of the. I'm on to IA.
So this is a good moment to break.
It's a good moment to start.
So we'll start again at 2 o'clock.
I will reflect on my Lord Justice Singh's question. Is there anything else that I ought to be reflecting on at lunchtime other than trying to speed up?
Not apparently, no. Thank you very much.